harm so many of these products are causing. Thank you.
I call the Honourable Member Kevin Haig.
Thank you very much, Mr Chair, and it's a good point for me to pick up from with the Minister's contribution, which I welcome and thank him for, and indeed thank him in general for what he's added to this bill, because it is a better bill than the bill that the Honourable Peter Dunn introduced to this House. Indeed, sir, what the Minister says is quite right, that I'm sure that no member of this House is interested in passing legislation that increases the risk to New Zealanders, that sees unsafe products on the shelves. And indeed, this issue of animal testing, I think, highlights an error of logic on the part of the government, and I'm going to come to that shortly. As Ian Lee-Scalloway has said, the amendment made by the Select Committee to the bill, to the purpose statement, is a very good one, so that we now clearly set out with the objective of protecting the health of and minimising harm to individuals who use psychoactive substances. And, Mr Chair, that's a great step forward, and indeed that should be the prism by which we evaluate the rest of what's in the bill. And actually, through consideration of the rest of the bill by means of that prism, in fact, some errors emerge, and those are errors around the issues of animal testing, and that comes up in Part 1 and Part 2, and around possession offences in Part 3. I want to briefly touch on Clause 9 also, Mr Chair, which relates to the meaning of psychoactive substance. And Mr Chair, that meaning needs to be read against the offences for possession that are in Part 3. I'm going to come to that later when the House is discussing, or the committee is discussing Part 3. But I want to highlight that Clause 9, because that definition of psychoactive substances actually is pivotal to determining whether or not a person actually is in possession of an unapproved psychoactive substance, and actually goes to the heart of a fundamental problem with that possession offence as it's cast. In this contribution, Mr Chair, I want to speak specifically about Clauses 11 and 11A in relation to the Expert Advisory Committee. And in particular, in Clause 11A2 and 11A generally, the provision that is made for there to be no animal testing provided that a suitable alternative exists. And what I want to say to the committee, Mr Chair, is that this is a clause that, while superficially attractive, in fact ensures that the meaning of our law will be determined by the courts and not by this House. And Mr Chair, I believe that that is not the certainty that Kiwi mums and dads and users of psychoactive substances actually need. It's not the certainty that the manufacturers, importers and retailers of psychoactive substances need. What this House needs to do instead is to actually be clear about what kind of testing is or is not permitted. And Mr Chair, given that we are all concerned about safety, it seems to me that those who are opposed to the use of animal testing are not saying we oppose animal testing, therefore an increased range of substances not tested on animals should hit the shelves. What we are instead saying is that there should be a higher standard, a narrower range of tests that are appropriate. And that, in fact, imposes a higher standard on the manufacturers, importers and retailers of such substances. Dr Hutchison from Chair of the Select Committee has referred to a response from the interim Expert Advisory Committee, and I have to say, Mr Chair, that the Select Committee was taken rather by surprise by receiving the letter from this interim Expert Advisory Committee. It was a letter addressed to the Associate Minister of Health in response to a letter that the Honourable Peter Dunn, had sent to the committee seeking advice. And it's important when we consider what that group had to say that we acknowledge that that group did not have in front of it the submissions that had been made by members of the public, by experts, and indeed by animal welfare organisations in relation... Mr Chair.
The Honourable Member Kevin Hay.
Thank you, Mr Chair. They did not have in front of them any of those submissions. What had occurred is that the Chair had ruled all issues related to animal testing out of scope, and the National Party members of the Select Committee had refused a motion that I had moved and had been supported by members from Labour and from New Zealand First to hear those submissions nonetheless. So the National Party, and in particular the National Party chair of that Select Committee, Dr Paul Hutchison, ruled all of that evidence out of scope. It was heard not by the Select Committee, not by the government, not by the Associate Minister, not by the Interim Expert Advisory Committee. And so, Mr Chair, it's a bit rich for the Chair of the Select Committee to then come to this House and talk about the consideration that had been given to expert advice, because actually so much of that advice, so much of the evidence that would have been available was ruled out of order and not even considered. And Mr Chair, I need to address the excuse that has been given by the Chair of the Select Committee, Dr Paul Hutchison. He says, and he said it in the second reading also, that the clerk of this House actually gave advice which forced him to rule those submissions out of order. In fact, when the clerk came to the Select Committee, she was very specific that that was not the case. She said to us that any amendment to the SOP that sought to amend the Animal Welfare Act would be out of scope for the bill. But that did not mean that any submission that had been made to the Select Committee was automatically out of scope. And Mr Chair, I point out to this committee of the whole House that in fact we now have in front of us an amendment made to the bill as introduced that very extensively deals with the issue of animal testing. And Mr Chair, those amendments in clause 11A are not out of scope, and therefore submissions that could have led to those very same clauses or improved clauses would have been very useful indeed to the Select Committee. In particular, I draw the House's attention to the submission of the New Zealand Anti-Vivisection Society, which is addressed in the Green Party's minority view in the Select Committee report, and which sets out all of the suitable alternatives that could have been used to animal testing. And, Mr Chair, I have to say that in this House this afternoon and today, that we've already heard that the National Party members will be voting against Mojo Mather's SOP 260, but we have yet to hear a single argument why that SOP is not a useful addition to the bill. And Mr Chair, I think that's a major problem. So, just in my time remaining, I deal with one extra problem with clause 11A, which relates to animal testing that occurs overseas. Because the reality, Mr Chair, is that this clause that's now in the bill will not result in no animals being tested. It will result in animal testing, and much of that will occur in other countries. And while the clause as drafted actually puts a requirement on the authority to ensure that such overseas animal testing complies with New Zealand's Animal Welfare Act, in fact, there is no realistic way in which the authority can ensure that that takes place. And so 11A is certainly a major advance on the bill as introduced, but it contains very major issues around monitoring and compliance, and it ensures that on the pivotal issue of whether or not animals are actually harmed in order to determine whether or not these recreational drugs hit our shelves, on that very pivotal issue, it ducks responsibility, because what it will ensure is that it is the courts that actually make that decision. And I believe, Mr. Chair, that is not the correct way for this House to go about this. There's no requirement for us to do that, no requirement at all. Thank you, Mr. Chair, and I'll come back to that in later contribution.
Mr. Chair.
I call the honourable member Brendan Horan.
Thank you, Mr. Chair. I appreciate being given the opportunity